be very welcome to. We'd understand if you don't want to be shown on the recording. We will share the recording after the session, and then you're very welcome, obviously, to forward on to anyone in your organisations that wasn't able to make it. We are planning about an hour session this morning, might wrap up a little bit early depending how many questions there are. You're very welcome to put any questions in the chat as we go. Tom and I will both try and keep an eye on that chat, and if we can answer the question as we go, we will. If it's something that's not going to be covered or wasn't going to be covered in a lot of detail, we'll come back to it at the end. We'll also give you a few minutes at the end for any other questions that you think of at the last minute. And after the session, excuse me, we will, as I say, be sharing the recording and showing the slides, and also obviously sharing our contact details. So if anyone's got any questions that occur after the session, or any questions that you don't want to share publicly, then obviously please just get in touch with Tom or myself after the session, and we'll be really happy to arrange a one-to-one conversation. So what are we going to cover today? Well, we're looking at effective absence management. That was a bit of a mouthful. I couldn't get that out there. So what do we need to know? So hopefully by the end of this session this morning, we are going to give you a bit of a deeper understanding and overview of some of the key employment law issues relating to absence management. We're going to help you recognise and promote the wanted behaviours of good management practice. So what is it that we can do as management teams and encourage our managers to do? For those of you that are in the sort of HR or more senior roles, what can you encourage managers to do to get this positive way of managing absence, which will obviously help reduce absence as well. We're going to talk about your own internal procedures, the importance of following your own internal procedures. I'm sure many of you on the call have heard us say this over and over, but if you've written a policy and you've written a procedure, then please, please, please stick to it. We'll come back to that, but that's a really crucial point. And we're going to look at how we can balance the needs of caring for our employees, because obviously that's a really important point. Humans working for us, we need to look after their well-being, their health, but we also have practically a business to run. So how do we balance those needs of being caring, but also pragmatic and practical? So we've got a lot to cover this morning. I'm just going to ask Tom to keep an eye on the chat while I keep an eye on the lobby at the moment, because we've still got people arriving, Tom. So if you can keep an eye on the chat, then we'll be okay. Right, so some of the things that we know that managers come across, some of the issues around absence that organisations face, and hopefully we're going to help you answer some of these this morning. Your first question to you really is, what sort of absence issues do you have? What are the absence levels like in your organisation? Do you have lots of short-term absence? Do you have a sense that those are non-genuine? Do you have a sense that maybe people are too quick to take time off work sick? Maybe it's all very genuine, and it's just unfortunate where you've got high levels of absence. And maybe you don't have high levels of absence across most areas, but maybe there's pockets. That's quite a common issue that arises. There's a department or a team that happens to have higher levels of absence than others. Or maybe you have very low levels of absence, but one person who's been off for long term. There are all sorts of different issues, questions, challenges that arise in different organisations. So understanding what your current situation is the first key, and then thinking about what type of absence actually disrupts your organisation the most. And again, every organisation is slightly different. For some companies, people having a day off, a half day or a single day here or there is manageable, but for other companies that would be very, very unmanageable. So it's again thinking about the context of your organisation. What is it that's happening at the moment, and what actually is the most disruptive type absence for you? Just seeing all the responses popping up there.
Yeah, a lot of answers to what are the common issues. What are we seeing? Yeah, short-term absence on a Monday.
Yeah,
it's not unheard of.
No, absolutely. And we'll make sure we touch on that, what to do if you think that maybe the absence is not genuine sickness absence. And then, of course, right through to the other end, I can see a couple of answers coming in about sort of anxiety, long-term sickness often related to anxiety and stress. So we've got a whole spectrum, and we've got a lot to kind of consider when we're thinking about absence. So really what we would sort of start by saying is, are you and all your managers in your organisation clear on what process to follow when someone is sick? And do you know what's in your policy? And let's step backwards. Do you have a policy? And if you don't, then that would be a very first port of call to maybe start thinking about getting something written down so that we can aim for a consistent process. So once you have a policy written, you need to make sure you and your managers are aware of it, and so that you can recognise a breach of the policy and what types of breaches occur. Oh, and I can see the answers just popped straight away from Mariella saying lots of unauthorised absence, people just not turning up. And that would be, in most companies, a very clear breach of your policy, which will say you must notify us by X time on the first day of absence, by phone or by text or whatever your process is. So that's a really common breach of that initial procedure, where people don't actually stick to the timings or don't let you know at all that they're coming in. And so in some companies, we actually see two different processes run alongside each other here. There's a notification procedure, and we may have sanctions for people not following the notification procedure. And then there's the question about the actual absence. So almost in some companies treated as two separate things, which I think can be quite useful if you do have a challenge, like I've just seen a couple of comments in the chat, where you've got that unauthorised absence. Maybe it's worth splitting that out and making sure that you know the steps to follow for breach of notification, and then a separate procedure to follow for actual number of absences. So actually there's a lot of commonality of issues, but also quite a breadth of issues that comes up across organisations. And we're going to hopefully help you put into context how to respond to each of those types of challenges.
I think I'm due to go up soon. I used to go up once a month. I know, but I don't go now because you're not. It's a webinar. It's a webinar.
Some of the things you need to be considering are, what types of sickness absence do we have, which just looked at. What type of issues do you need to consider? What legal risks can we be aware of? And what can we actually do when we're looking at both short-term and long-term sickness absence? There are slightly different considerations that we need to take as a line manager when we're looking at those two different lengths of absence. Short-term absence is often dealt with through a system of triggers. So some of you will have come across those processes where you have a trigger when there's a certain number of absences or a number of days of absence. We then step up our process. We move into not just having return to work conversations, but actually start moving into more formal process. Maybe you use Bradford factor to track that. Bradford factor is a great process to work out those short-term, repetitive, possibly not genuine, possibly are genuine and bad luck, but those short-term, really disruptive absences. And we can be using something like Bradford factor or a trigger process to be keeping a really close eye on that. And we need to be looking for patterns. I've just seen someone in the chat say Mondays. Absolutely. Is there a pattern? Does it look like this individual is having particular days of the week off? I'll share this because it's a long time ago, when I was in my first and possibly even my second job straight out of uni. Payday Friday was always a day that we had very high sickness absences, because you could normally find me in the pub rather than at work. It was a classic, it was a group of youngsters, and that was what we did every month. Payday Friday, we didn't go to work, we went to the pub instead. If I was the HR manager now, or my own line manager, I'd be sacking myself quite clearly, because there was a very definite pattern to my absence, and you may have come across others. I worked in large retail for a long time, and we used to have to be very, very hot on looking at absence when, for example, Wimbledon was on, or when the World Cup was on and England were playing. So we'd know that there was likelihood that we were going to see high absences on those type of events, and we'd be looking for patterns in people's absence. when we have got these tracks, we've got to keep a track of the sort of triggers, keep a track of of patterns, and then we've got to have a conversation with our members of staff to understand the exact reason. What are they telling us why they were absent? What reasons have they given us? And we need to be looking at keeping documentation for that. So self-certifications, any absence up to 7 calendar days should be self-certified, and we should be keeping notes of those self-certification. But we should also consider whether we're going to use return to work conversations. Some of you will be very familiar with a return to work conversation. Others may not have come across them, but our view, reality, our advice, I'll see whether Tom agrees, is that we would suggest that a return to work conversation with every single person after every single absence, even if it's only 1 day, is really good practice to get into, because you've got that consistency. Then there's no opportunity for someone to say, oh, well, you're having this conversation with me because you don't believe me, you're calling me a liar because you didn't have this conversation with my colleague next to me. So a return to work conversation doesn't have to be very formal or very structured, but it is a great way to establish the individual's reason for the absence and start to have that conversation with them about why they've been off, and showing that you are keeping a track, a notification of what's happening. So we'll talk a little bit more about short-term absences in a moment. If you've got someone who's been off longer term, now I think the official stats say long-term absence is officially called 4 weeks or more. I think that for many businesses, actually a lot less than that can feel like a long time. You know, if someone's crucial to your team, maybe that they're a key employee, maybe in a small business they wear lots of hats. Someone who's off for a week or two can feel like a long time, but the official CIPD certainly definition of long-term absence is 4 weeks or longer. And we've got a slightly different approach here, because actually we've probably got some more medical understanding to achieve, to understand why they've been off for that length of time. They're not there every day for us to have a chat with. You know, we're going to have to use different processes for keeping in touch with them. We're going to have to use different processes for getting medical information from them. And we need to be mindful with any long-term illness or any long-term recurring illness that there could be a risk of this falling under the heading of a disability, and therefore we have all the obligations on us as employers around disability discrimination. So we just need to make sure that we are very sensitive and we take this slightly different approach in longer-term absences. So I won't talk much more. I'm going to hand over to Tom in a second, but I just wanted to really call out the importance of line managers. We've got some people on the call who are frontline managers themselves. We've got people on the call, I think, who are HR or senior managers that are advising line managers. And in absence management, as in pretty much all employment issues, the frontline manager is absolutely crucial to getting this right. The frontline manager is that first point of contact between the employee and the organisation. You will ideally be the one taking the first sickness call in the morning, or maybe a text. I've seen some comments in the text that people are using in the WhatsApp. People are sending in WhatsApps or text messages and not making phone calls. The line manager is the one that gets that information first off. The line manager is the one that receives the fit note or the self-certification. A line manager hopefully holds a return to work interview and gets support from HR when needed. And so as line managers, it's so important that you know your policies and your procedures. So if you aren't familiar with your own internal processes or your own internal policies or what's been published and shared, that would be my first next step for you after this session, is to go away and look up what your internal policies say. Talked about lots of paperwork type scenarios there. I'm going to hand to Tom, who's going to talk us through what we need to do with each of these bits of paperwork and how we need to keep them safe and secure.
Yeah, and just a short one, really. I don't want to spend a long time talking on this slide, but unfortunately it's something that you do see often, and it's something that does cause issues around record keeping. It probably goes without saying that throughout any of these processes, but if you're helping somebody deal with short-term absence or even long-term absence that we'll talk on in a bit more detail a bit later. You want to be documenting what you're doing. And obviously we are lawyers and we think worst case scenario, but it is pragmatic to think if we're in an employment tribunal, we have to demonstrate that actually we've done what we can here. We've put supportive measures in place. We want to have a record of that. We want something in writing to show what we're doing and what we're doing to support somebody. Something to be aware of, though, anything about someone's medical conditions or reason for sickness absence is going to be sensitive personal data. It's a higher threshold in terms of what you need to do to protect that and make sure it isn't disclosed under GDPR rules. So it's important to stress, whether it's managers that are obtaining this information or HR that are processing it, that it's kept confidential. You're not leaving documents lying around on a desk for anyone to see or anything ridiculous like that. Again, unfortunately, it does happen, which is why we just want to hammer home the point that where you've got any information about someone's medical conditions or reason for absence, keep it as sensitive personal data. Do you send an all-team email explaining the absence? Again, this is something no one does deliberately, but we see it often. Heidi, you probably see it as well. Just a one-all email to the team to say, sorry, Carrie's not coming in today because of X, Y, Z. You think nothing of it, but you've probably breached GDPR there. You've disclosed something probably without her consent that is medical information about her. So avoid doing that. If the employee's happy for you to do that or wants you to, then that's fine to just check and make sure you've got their consent before sharing that. And so rarely is it necessary to give a reason. Most people don't ask. So if the employee wants people to be updated, then fine, but normally just a quick message, they're not in today, let me know if any questions is fine.
I think that does come up a little bit more when people are off longer term, Tom, doesn't it? So if you've got someone who's suffering from a longer term illness and they're going to be away for some time, then their colleagues feel that they may, I was going to say feel entitled to an explanation. That's not really what I meant, not quite the right word, but it's it's useful again then to think, well, how can we get consent from the individual to agree what we should be sharing so that the colleagues can be supportive when covering a long-term absence.
Yeah, and hopefully that could be achieved by just a casual conversation with the employee. Just to let know, people are obviously going to be concerned about you. They're going to be worried. What is it you'd like us to tell them? Can we come up with something that you're happy with, that we can share to let people know, just so that people aren't worried? How long do you keep records? Check your data protection policy. Should be no longer than is necessary, but equally general practice about 7 years to be keeping your records. All I wanted to talk about on record keeping is just a bit of a reminder. These are probably things that most people are doing already, but where you're dealing with medical information, it's sensitive personal data under GDPR, and it's just a higher threshold. So make sure that you are keeping records so that you can prove and you can show that you're doing the supportive measures that you're doing, but also be aware of the confidential nature of that type of information as well. I do have control of the slides. Thanks, Heidi.
No, you don't. I don't think yours moves. I'll do that for you. I'm on it.
Okay. Perfect. No, thank you. So yeah, short-term absences. Obviously, like Heidi mentioned, it can sometimes mask wider issues within workplace, whether it's personal issues, workplace stress, disengagement with somebody in their role. So it's something that from the outset, having a casual conversation, trying to find out if there's a reason, but then investigating it if necessary. Like Heidi said, just check if the notification rules are being followed. And this is something we saw actually in the chat at the start. A lot of people saying people don't want to call. Our policy says, well, we want a phone call. You need to call your line manager, but we're getting a text or an email instead. Really common, something we see a lot of. You absolutely within your rights to remind people, look, this is what our policy is. It's not unreasonable to ask for a phone call or for notification before their start date. Can we treat it as a disciplinary issue? Yes, Would I go straight into treating a first-time failure to notify in accordance with the policy as a disciplinary action? Probably not. But it's something to be aware of. Repeated failure can absolutely become a conduct issue, and especially if you've reminded somebody and you've got a reason why you want them to comply with that reporting obligation. Eventually, you might take a view, a more measured view, and think, well, actually, we need to deal with this as a conduct issue. There's a legitimate reason why we need you to report this. We can't have you just not turning up.
And just before, sorry, just to go back, just to take a slightly step back before that, if the managers are responding to, if you're getting a WhatsApp with someone saying, oh, I'm not coming in today, and the manager responds to that WhatsApp and says, oh, I'm sorry to hear you're not very well, see you tomorrow, and doesn't remind the individual about the process, you are condoning it and therefore encouraging it. So it's going to keep happening. It really is. The only way to change that is by managers calling it out every single time. And as Tom says, you may or may not choose to implement disciplinary proceedings, but actually reminding and saying, this doesn't count, you know, you must pick up the phone to me. It is the only way to change that behaviour. So it's frustrating as managers that people don't follow the process, but actually the only people who can change that are the managers.
Yeah.
Sorry, Tom, I interrupted you again. Right. Look, it's terrible. Okay. I just can't. I'll stop now.
Not a problem at all. No, please do. It's always great to have a couple of perspectives in there as well, and especially when it is that the best key tips for managers having those conversations. So please do. Again, this next bullet point, suspecting when someone is genuinely or not genuinely ill. I think we've seen a few comments at the start of hints at that recurring theme on a Monday, perhaps straight after a weekend, a common trigger where people might start to think, is this a genuine illness, or is it something else? Is it somebody giving us a different reason for X, Y, Z? I'd say tread carefully. If you suspect that an absence isn't genuine, don't jump straight in with being accusatory, but do investigate it. You're well within your rights to investigate it as an employer. Take steps to look at whether there are any patterns, ask questions of the employee. And now it can always be awkward when you're asking somebody to prove why they're off. Slightly easier where it's more than a few days and they provided a doctor's sick note, because then at least you've already got a medical view, or at least an opinion. So it can be trickier if it's short-term absences of just a sporadic one day here or there, but that's when something like an occupational health referral, which we'd more normally see in case of long-term absences, but it is something that can still be useful in the short-term absence to get a view on why is this person taking lots of sporadic one day here, one day there, and if they're different reasons each time, then maybe we want to just be having a conversation with the employee, say, look, is there anything we can do to help you here? But ultimately, if we've got reason to believe that they're not genuine, we're not expected to just have to put up with that. If we think somebody is always taking a Monday off because they're having a busy weekend, then you can treat it as a conduct issue. And as an employer, you'd want to investigate that, form a view as to whether this is genuine or not. But ultimately, misconduct would be a misconduct issue. Somebody's taking time off saying that it's for sickness absence, but it is not. And again, then you would want to follow, potentially you've got the option of following a disciplinary process, depending on their length of services, depending on what the options are available following that. But yeah, ultimately, you have a right to ask those difficult questions and ask for evidence. Again, keep that consistent, keep it documented so that we know what we're doing, we know what we're asking for, and see if there is anything else that we can do. Got anything more practical tips to throw in there, Heidi?
I think it's just really tricky at the moment for asking people for doctor's notes and for evidence of sickness absence is very, very difficult, because we know that it can take 3 weeks to get a GP appointment. So if you've got any sort of EAP or health provision, health service that allows for a private GP appointment, then those are really useful to remind people of. If you don't offer that sort of service, then you're going to have to accept that not everyone can necessarily get a GP appointment in the first 7 days, because to get a sick note is a challenge. So it's really difficult. And I think you're absolutely right, Tom. We don't have to accept people being absent. if we don't believe it's genuine or they can't evidence the illness. But we also have to bear in mind the practicalities of the real world right now. I don't know how recently anyone's tried to get a GP appointment, but in some cases it can take 3 weeks or longer. So it's a tricky one.
Yeah, we've even seen backdated doctor's notes where they just haven't been able to get one until much later. One thing to note is fairly recently there was a change in the law that allowed pharmacists to issue fit notes as well. That might alleviate the pressure a little bit. We might see fit notes more and people are even aware of that. So I think if someone is saying they're struggling to get a doctor's note, remind them of that as well, that there are other avenues that they can get a fitness note as well. It might start to alleviate some of the pressure and make it a bit easier for people to get fit notes.
And it might be worth a conversation about whether your EAP provider, you can increase the levels and some of the, to offer that private GP telephone video consultations can be, they're actually not massively expensive in some cases. We've got some providers, so if anyone wants to have a chat about those, we've got some people that we might be able to recommend. I'm sure you've come across some as well, Tom, but they don't have to be massively expensive. But it's an access, it's an availability, because if you've got this challenge, then this might be something that helps you alleviate that pressure. I've just picked up, there's a question in the chat from Mark saying been some pushback from managers needing to record a return to work meeting if the absence has been for just 1 day, because the managers don't like forms. Chasing individuals can be a challenging experience. One solution might be automating the process on a HRIS, but are there any other suggestions on making this process easier but ensure the meaningful return to work process is done? We'd still want to see the manager having a conversation with the employer on the return to work to ensure they're okay. What are your thoughts around return to work interviews or conversations, Tom?
Yeah, I mean, it'd be great if you could have one for every short-term absence, but the practicality is it's incredibly difficult. People just don't always have enough time. Getting somebody to self-certify, even if it is just an online form that does have a space for a comment and they can say, yes, I'm absolutely fine, or any support measures that they might need in place that they can record there is quite useful, because at least you've got that something documented when they've come back and they've either self-certified that they're back and able to pick up their full normal duties as normal, or they might need some sort of phased return, even if it's been a relatively short absence.
Maybe there could be an option for requesting on there that they do have a conversation. So maybe when they fill in that return to work self-cert themselves, there could be a checkbox to say, I'd like to talk further to my manager, and then those ones that we know the managers have to pick up.
Yeah.
Even if we can't get the managers to do all of them.
Yeah, and even just an email offering, even if they don't want to take it up.
Yeah,
it's a good step.
Great, thank you. And Tori's just asked, can we use return to work conversations to remind them about correct absence reporting, or should it be purely about the employee's well-being? My view is yes, absolutely. You can use that conversation to cover anything. It's relating to the absence. Yes, of course, you want to check on their well-being, but absolutely opportunity to remind them about absence reporting as well.
Yeah, I completely agree. As long as you're not drifting into treating it as a disciplinary issue in that meeting, if it's just a casual reminder, sensible time to do it.
Yeah, and you make a note then, because it's part of that conversation. It's recorded that you've made the note, so next time that they do the same again, you can go back and look, and then you can take it outside into a disciplinary process if you choose to. But you've got the initial light touch conversation recorded and dated. Wonderful. Sam says Bradford score on the return to work. I think that's a really good process. Those of you that use Bradford factor or Bradford scores there, to let someone know at their return to work conversation what their Bradford score is a really useful thing to do, because it's not drifting towards the disciplinary point yet, but it is reminding them that we are tracking and monitoring their attendance. So I think we've picked up all of the comments about short-term absence in the chat there, all the questions as well. Shall we move on to long-term absence?
Yeah, let's move on. There's a few questions about stress and anxiety. I think we'll cover those off.
We can cover off here.
Absence. Yeah. I won't talk for everyone this slide because Heidi, I think you gave a great overview at the start, but a slightly different approach. I'll say slightly quite a different approach when you've got long-term absence, whereas absence typically more than 4 weeks or so, more than a month. You treat it quite differently to a short-term absence. It's much more about assessing and supporting somebody to get back to work. Occupational health takes a far bigger role in long-term sickness absence, and I'll touch on that in a bit more detail in a second, but it's a really useful tool to make sure that employers, we can understand whether we're doing everything we can, whether there are any more support measures we can put in place, potentially whether somebody has a disability that we need to consider, and if that person is disabled, whether we're complying with our legal obligation to make reasonable adjustments, to take any steps to alleviate the impact of someone's potential disability. Whilst it's about sort of supporting someone and getting them back into work, unfortunately, we all know the reality is that sometimes somebody may have a condition or an injury that means that they cannot return to work, or they're not going to be able to return to their existing duties, or in a way which is reasonably acceptable to us as the employer, which is where this does unfortunately tie into capability dismissals, which I'll talk about in a little bit more detail later on as well. But where we're dealing with long-term absences, this is where we might need to consider whether a formal capability route is the most realistic option. And obviously no decisions are made until we've concluded a capability process, and it may be that actually with the measures and support mechanisms that we put in place, that person does become able to return to work. But from a legal perspective, if it does come to the point where we cannot maintain their employment, it's not looking realistic that they're going to return to work, then we may proceed with a capability dismissal. But I'll touch that in a little bit more detail in the next few slides. I wanted to talk a little bit more on disability discrimination. Now, there are various different types of disability discrimination claims that can potentially be relevant where we're dealing with someone who's on long-term sickness absence, but the most obvious one, and something to be always thinking of, aware of, and to be aware of, is the duty to make reasonable adjustments. But firstly, what is a disability within the legal definition? It's defined as a physical or mental impairment as a substantial and long-term impact on someone's ability to carry out day-to-day tasks. So substantial means more than just a little bit. It has to actually impact somebody throughout the day in most days. Long-term, what does that mean? It means the condition has impacted them for either 12 months, or it's reasonable to expect that that condition is going to impact them for 12 months. So it might be that they've been diagnosed with something fairly recently and they haven't been suffering from that for 12 months. But if it is a condition that we know they're likely to still be suffering from in 12 months' time, and it has a substantial impact on their ability to undertake day-to-day tasks, then it's very likely that they would meet the legal definition of having a disability. There are some conditions that are automatically considered disabilities, such as some visual impairments, cancer, HIV, some of the serious conditions that the law accepts are automatically going to be classified as disabilities. It's quite limited though, and there's not a huge number that fall under that. So with most conditions, they would have to, you'd be applying the test of whether it's substantial and long-term. I've seen a lot of comments in the chat box commenting on mental health conditions, stress, anxiety, depression. It's something that I'm sure, Heidi, you've probably seen more and more of over the last few years. I think people are more aware, more likely to get diagnosed than they were only a matter of years ago. And it is something that absolutely can amount to a disability. Stress, not so much. Stress doesn't typically amount to a disability under discrimination laws, but anxiety, depression are both conditions that can absolutely amount to a disability. And then if someone has a diagnosis and we are aware that it's substantial and it's long-term and they're going to carry on being affected by this, then it's likely to be a disability, which means we're under a duty to make reasonable adjustments. That duty to make reasonable adjustments only applies when we're aware of that disability. Not only do we need to be aware of the condition that they have, but also we need to be aware that it is substantial and long-term. Once an employer is aware of that, or they have enough information where they should reasonably be aware that they ought to be aware that it meets the definition of disability, they are under an obligation to make reasonable adjustments. Reasonable adjustments can be incredibly varied, incredibly broad. Generally, it's any steps, any measures that can be put in place, any adjustments to the way that employee might perform their role to help them to alleviate the impact of their disability. So some examples there, finding a different way to do something. It might be a physical adjustment, obvious ones. If somebody is physically disabled, if they are in a wheelchair, then ramps and access would be reasonable adjustments. To come back to some of the mental health conditions, anxiety, depression, can be far more difficult to identify what are reasonable adjustments. What can we be doing to help? Because everyone is different. Everyone suffers from those type of conditions in slightly different and nuanced ways. So it can be very hard as managers or HR professionals that are not medical experts to understand what we need to do. And that's where occupational health referrals and getting real medical advice can be crucial, which is why I just want to touch a bit more on that. But the key point to remember is that, unfortunately, if we're dealing with someone, we're trying to support somebody who has been on long-term sick, we should always be considering, well, is this a potential disability that we need to make more allowances for? Are we under a legal obligation to put measures and steps in place? And look, being the cold lawyer about this, obviously we don't want claims for failure to make reasonable adjustments. We do not want disability discrimination claims being brought against us, but on a more practical and human level, also, obviously, we want to be doing what we can to support somebody and get them back into work. We don't want somebody to be signed off for 6 months and unable to come back. If there are things that we can do, small adjustments to the way that they work to help them come back and rejoin the workplace.
Yeah, we've had a question from Neil in the chat saying, is it always clear when someone has a disability? Is it black and white? And I would say no.
Not. No, absolutely not. In some cases it will be. In some cases it will be. With some physical impairments, then yes, it may be far easier to consider whether that is a disability or not. But certainly, if, for example, if somebody is diagnosed with ADHD, that is something that can absolutely amount to a disability, but it won't necessarily always do that, because again, it's a condition that affects different people differently, and it's not always going to tick the box of being a substantial impairment. But on the flip side, it absolutely can. So no.
And there's a further question with something like ADHD, for example, is that the waiting list to get a diagnosis can be 3 to 4 years for adults, depending on your location in the country. And actually, so we've got more and more people self-diagnosing. So you may well have people coming to you saying, I've got ADHD and I need you to make these adjustments. They haven't had that formally diagnosed. But if they're saying it's this substantial impact and it's going to be for the rest of their life, then that might be something that you need to bear in mind, even without that formal diagnosis.
Yeah, it might be. It's always a tricky one. And yeah, the point is exactly right, that with things like that, there are long wait times to get diagnosis. But ultimately, it comes down to what is reasonable for us as employers to conclude. If we're asking questions and someone doesn't have a formal diagnosis, I'd be minded to say, well, look, it's not necessarily reasonable, nor are we expected to acknowledge that somebody has a condition that most people will be diagnosed with if they don't have a formal diagnosis. Doesn't mean we might not want to support that employee and do what we can, but it does make it more difficult for that employee to be able to say, look, you're under a legal obligation to make reasonable adjustments.
We had another question on reasonable adjustments just before we move on. May says, what happens if a company isn't able to make all reasonable adjustments for an employee, which means they're not able to fulfill their role? And I think we're going to answer that when we look at moving into a capability procedure and potentially a capability dismissal.
Just finding
So what happens if a company isn't able to make all reasonable adjustments for an employee, which means they're not able to fulfill their role? And the key word here is reasonable. And that will be different in different organisations depending on the size and nature of your business. What's reasonable for a multinational with hundreds of thousands of staff might be very different from what's reasonable in a business of 5 of you in one office. It might be different depending on the type of role the person does. It really is context driven about whether it's reasonable. So your best steps are having the conversation with the individual, understanding what it is they're looking for in terms of reasonable adjustments. And we're going to come on to occupational health in a moment, who are also going to be very, very helpful in providing you some advice on what those reasonable adjustments might be. And then you need to take some advice from the HR teams or the legal teams about, if you're not going to be able to support it, the advice is always to look at how can we make this happen, not how can we turn it down. But if you reasonably can't achieve it, then there isn't an expectation to go over and above what's reasonable. And I've used that word lots of times in that definition, because that's the wording in the law, isn't it, Tom? We haven't got the clear lines about what is and what isn't reasonable.
Yeah, you're absolutely right. The short answer to that question is, unfortunately, that if you haven't made the reasonable adjustments, then you're likely liable for employment tribunal claims. But you're absolutely right that the question is, well, was it reasonable in the first place? If it's something that we were just not going to be able to do, was it reasonable? If it wasn't reasonable, then we're not under an obligation to make that adjustment.
Yeah. And the last question here on reasonable adjustments from Nicola, I think, says, what if someone has a disability but doesn't want it to be disclosed to their line manager and they've said they don't need any adjustments? Well, we go back to the point that you only need to make adjustments when someone's made you aware that they've got a disability that requires reasonable adjustments. So if they're not asking for anything and they've chosen not to disclose an illness or a disability, then you have no need to, there's no requirement for you to do anything.
Yeah, absolutely. If we're not aware
Tom,
of
I can't see. Yeah.
If we're not aware of a disability, then we can't be expected to make reasonable adjustments. Obviously, it comes to the point of whether we ought to be aware or reason to be aware. The onus is still on us, though. If we become aware, the onus is on us to investigate whether there are any steps. So we can't always rely on saying, oh, this employee hasn't asked for anything or has said no. We should still be at least having a conversation, discussing anything that we think might be helpful for them. And presumably, I'm wondering, Nicola, whether your question is around it might have been disclosed to HR, but not necessarily disclosed to a line manager. And it's a really tricky situation, but it is something that happens. We're under an obligation still. If it's been disclosed to HR as an employee, you're still under an obligation to make reasonable adjustments. So I'd always try and encourage the employee to discuss it with their line manager and say, look, we'd like to support you, but to do that, we want everyone on board that needs to know, your line managers being one of those people, to help implement reasonable adjustments. If not, then you're in a difficult situation where we might need to try and make some adjustments, but not always disclose it. I would always, Heidi, I'm sure you'll agree, try and have a conversation with the employee and explain why it's more helpful for them and why we can do more to support them if your line manager is aware.
Absolutely. And if their performance is great and they're happy and the manager's happy, then it's, while it's plain sailing, that's not so much of an issue. Where I can see this might arise as an issue is when, let's say, the line manager decides that they need to start a performance process with the individual. Maybe they're not meeting targets or they're not working in the way the line manager is expecting. And at that point, if you're aware of it as a HR team, you're going to need to really push the employee, I think, to try and disclose, to try and encourage them to disclose, because otherwise they might end up going through a performance improvement plan, implemented by a manager who didn't know about the disability, when actually reasonable adjustments would have been not to do that PIP. And so that's going to be the real time when it's really important that we do encourage the employee to share with their manager. Or you'd be looking at maybe other roles in the organisation. Is there a different team they could be part of? If there's a personality clash and it's causing them stress and anxiety, you might be needing to look at other options. But yeah, as Tom said, really, if there is an issue, we really need to encourage them to share that information with their line manager. Okay, I think that's the questions there for now. We've mentioned occupational health a few times.
Yeah, I'm just going to whiz you through. I'm conscious of time and want to be able to get through content here, but this is a really useful one, occupational health referrals. We've mentioned when we might use them, potentially with short-term absences, but more likely where we're dealing with a long-term absence, and we want to understand potentially whether this employee is disabled, whether there's anything else that we can do, but also to get a view on, is this person going to be able to return, or are they going to be able to return on a full-time basis, or however they were previously working, and what's acceptable to the business. A lot of people don't get the most out of occupational health referrals, and I think it's often a combination of not using the right provider, using a provider that will just do a lot of tick boxes. And Heidi, I'm sure that you've seen some that will just copy whatever the employee says. If the employee says, this is how I'm feeling, this is how my condition affects me, they will just copy it out and send it on, which is incredibly unhelpful, because the chances are you've already got that information from the employee anyway. And it's not helpful to have that exact same just written in an occupational health referral. So the provider matters. If you need any advice, let Heidi or I know. Heidi, I'm sure that you've got occupational health referrals that you could refer as that you can recommend.
Yeah, we've tried out many over the years, and we've got a couple that we that do give us that commercially focused information that do come back. You have to give them lots of information up front, explaining what the job role looks like, all the pressures of the job, you know, that all the job description, all of those things in the beginning. But it's worth the effort of putting all that information into your OH referral, because you'll get much better advice out.
Yeah, and that's exactly that bullet point there. You often get what you put in, so you don't just want to send it with a one line, is this person disabled? That's not going to be helpful, because the chances are you're not going to get a clear answer anyway. They might give you some guidance, but it's really useful and really helpful to get the most out of an OH referral by being specific in the questions that you're asking. Now, this can be questions about fitness for the role, adjustments, prognosis. It might be a question as detailed as, is this person likely to be able to return to their full duties in the next 6 months? If you can get an answer to a question like that, then it's really helpful in being able to assess when is this person going to be able to return to work. And also, if you do have to go down a formal capability route, you've got a medical evidence, a medical opinion on the likelihood of this person being able to actually come back, which makes it more reasonable if you have to make a decision on whether we continue this employee's employment or not. Contractual clauses, you will see contracts with clauses that say this employee consents to a medical examination or an occupational health referral. It's nice to have in there, but honestly, you can't rely on those. You can't force somebody to go have a medical examination just because you've got a clause in your contract. So nice to have, it sets some expectations, but don't rely on it. Don't force an employee just because you've got that term in their contract. Likewise with disciplinary action, it's rarely is it ever going to be appropriate to apply disciplinary action because somebody has refused to go to occupational health, unless there's something quite a lot more to it. Perhaps their conduct, the way they've engaged with occupational health, maybe, but rarely is it going to be suitable to do disciplinary action. It is better when somebody refuses or doesn't want to go to occupational health, to explain to them that, okay, that's fine, but we may need to make decisions on how we support you and the future of your employment based on the medical information that we have available. So based on all of the information that we do have, and if that is without an occupational health referral, we are limited in terms of what information we have. The employee refuses to show you the report, yes, they have a right to withhold it, but again, it comes back to the same point of explaining to them, well, look, we can only support you if we understand what there is to do. We may need to make decisions based on what we know without that occupational health referral. I'm conscious of time, Heidi, there's a bit to get through, but there are a few questions. Have you read any of the questions? Is it something we might cover?
No, I think we're okay. There's lots of chat in there about OH at the moment, about asking about OH providers, and Sam's just mentioned that they used Reality HR, the OH provider that we recommended, and they've had a great result where they were able to dismiss a long-term employee, someone who was on long-term sickness absence, which was good for the company, but also good for the employee, as they were unable to continue working and needed to put their health first. So actually, they had a great result. So a couple of people have asked for details, so I'll be in touch afterwards with sharing those conversations. Thanks.
Perfect. Good. Yep, if there are any other questions, we can definitely address them at the end as well. If people want to hang on for a little bit longer as well, it's not a problem for me.
Yeah.
Look, and I mentioned this a bit earlier about capability dismissals, and like I said, whilst the key objective really with any absence, long-term absence management is going to be supporting someone getting back into work, ultimately that's just not going to be possible in all cases. And we don't need to continue having somebody employed or paying them or potentially them being in receipt of sick pay if they're just not likely to return to work, or they're not going to be able to return to their normal duties. So there are times when it becomes necessary to follow a formal capability process. This becomes, I would say, more relevant where somebody has more than 2 years service, so they have unfair dismissal protections. When someone has unfair dismissal rights, we need a fair and legal basis to be able to end their employment. Now, capability can amount to a fair reason. As part of that, you'd have to follow a fair process in coming to the decision, and that fair process is the capability process, which we can talk through in a little bit more detail on the next slide, but it's ultimately something we need to be aware of. Not only is it likely to be people that have more than 2 years service and unfair dismissal rights, though, because often, as we've mentioned, where there is somebody on long-term sickness absences, quite likely there might be a disability issue as well. So even if they don't have unfair dismissal rights and the right to bring an unfair dismissal claim, we need to be aware that there could be disability discrimination issues as well, and therefore still a legal requirement that we follow a formal capability process, especially where it's disability related, and we have to ensure that we are meeting our duty to make reasonable adjustments and that we are not treating somebody detrimentally or unfavourably because they might have a disability or something arising from their disability. Now, Heidi, I feel like we could probably do an hour-long session in itself just on a formal capability process. So this will be a bit of a whistle-stop tour, but just flagging some of the key points. Transparency, it's important. You want to be explaining the process to the employee, make sure that they know what's happening, why it is happening, make sure they understand the purpose of it. Communication, regular dialogue. You don't want to have somebody who's been on long-term sick leave for 6 months and nobody has checked in, nobody has spoken to them. Consultation, employees need to be involved in the discussions about their situation, about their prognosis, the likelihood of them being able to return to work. And when it comes to the capability process, typically you're going to want a meeting with them, a formal capability meeting, a hearing where you're discussing, trying to encourage them to go to occupational health if they haven't already, so that you can, again, get a view, make sure we're doing everything we can. You want a review periods, and there is no one size fits all for how long a review period is going to last or how long a capability process might last before we might need to move to dismissal. It's circumstantial and it will depend on the nature of somebody's role, what us as a business can afford. A huge multinational business might be able to make more allowances and have somebody on long-term absence for slightly longer than a small family-run business with just a handful of employees, where it's far less practical to maintain someone's employment. So there is no one size fits all, but there will still need to be that review process, checking in with the employee after the first capability meeting and explaining to that employee what the purpose of this process is, and that we may need to take a view, and ultimately we may need to form a view on whether there's a realistic prospect of them being able to return to work within a time frame that is going to be realistic and reasonable for us. Get the employee's view as well as part of that. Be asking them, what do you think? Do you think you're going to be able to come back to work? Are you going to be able to come back full time? Are you going to be able to carry on with your normal duties? Up-to-date medical information is a key one, and I think, Heidi, you'll probably see this too, something that is often overlooked and forgotten. A lot of employers might think, well, we've got an occupational health referral, we've got a view on whether they're disabled or not, we know what we've done, we've now followed a capability process, but 6 months have passed maybe, it might be 6 months, 3 months, could even be a little bit longer, and we're now having to move to dismissal. it's good that you've got the occupational health report from that stage, but at that point it's 6 months old. You're in a much better position legally to be able to defend any claims of unfair dismissal or failure to make reasonable adjustments or any other type of disability discrimination claim if we've got more up-to-date medical information, if we've got a GP note or another occupational health referral later towards the end of the capability process with an updated view. It might be that things have changed, it might be that nothing has changed, and if nothing has changed and there's no change in the prognosis or likelihood of them coming back to work, then we're from a legal perspective in a stronger position to be able to move ahead with a dismissal, because again we've shown that we have got up-to-date medical information. We're taking any reasonable steps that we can to determine whether this person's able to come back to work or not. And lastly, they're looking at alternatives. Not always.
Before you move on to alternatives, Tom, can I just ask a quick question on what you were just saying there? If you've got that gap of 6 months where you've been working on this capability procedure, you mentioned 6 months then, and that was just, I'm guessing, a sort of a ballpark figure. But we've had a question, is there any guidance on how long you should support someone on long-term sick before you move into this kind of decision-making around capability and dismissal? Or does it really depend on the type of absence and the medical prognosis? I've just started writing an answer in the chat to say it really, for me, it depends on the medical prognosis. If on the first day of absence, the medical practitioners are saying this person will never work in this industry again, well, then you wouldn't wait 6 months.
Exactly.
But if there's any indication that there's going to be a full recovery or even a partial recovery to enable them to come back on with reasonable adjustments, then you would slow the process down.
Yeah, you're absolutely right. I think if you know that someone has a terminal illness or as a life-changing condition, that means that it's incredibly unlikely they're ever going to come back and work for us again, then there's very little value. There's very little value in delaying a formal capability process. But on the flip side, if someone has broken their arm and they're going to need a month off work or so, then there's zero value in starting a capability process there, because you're not going to be able to dismiss someone, nor are you probably going to want to dismiss someone if they're going to be back in a month's time. So yeah, it is circumstantial, but absolutely agree with your summary there. Just back to the redeployment and looking at alternatives, like I said, not always going to be appropriate. There's not always going to be other roles within the business, but if there are roles with slightly different duties that person might be able to do, then we should be looking at it, both from a legal perspective, but also a human practical perspective of, look, is there an alternative position that we can offer this? Are there any other adjustments that we can do? But we've likely already considered that. And it should be last resort. Dismissal should be last resort after we've looked at all of these steps we discussed and considered all of the evidence. But ultimately, if you've done all of those things and there is little chance of this person returning to work, then a dismissal is likely to be fair and lawful.
Super. I'm really conscious of the time. Apologies, everyone. I think I started off talking too much in my early slides, and we've run out of time. We've got one question that I don't think we've answered, Tom, that I've just wanted to raise quickly. Liz says, does the capability procedure apply to regular sickness patterns over a long term if there's a known condition?
It can do, yeah, it can do. And this is the sort of case where maybe that somebody is taking 1 day a week off, but they're in the other 4 days a week if they're full time, and it absolutely can. Yeah, it's slightly different and a modified capability process, but still a capability process where we're essentially saying we're forming a view of you're not able to undertake your role in the way that we need you to be able to do. And as employees, we're entitled to form that view if we can justify it, if we can justify why it's difficult for the business to have to make up for the fact that somebody is taking 1 day a week off, then that is still a capability issue. And if that's related to an illness or a medical condition, then it still becomes a capability process of, unfortunately, you're not able to perform the role in the way that we need you to. It's rarer, and I'd be stressing that at that point you want to take some legal advice on how you're implementing that type of capability process, where it's a slightly different one and somebody is still working, but albeit not all the time. But yes, you can absolutely still move to a capability dismissal in those circumstances.
Brilliant.
One thing I know we're pushed for time, but I just really quick want to cover off, because I haven't mentioned it yet. A lot of employers might consider a settlement agreement at this point as an alternative to a formal capability process. And actually, if somebody is on long-term sick leave, it might be a better option for them as well. They might welcome the chance of actually being able to avoid a formal process if they've got no intention or no expectation of being able to return to work. Sometimes an off-the-record, without prejudice conversation and coming to an arrangement can be the less risky option and the easier option for everyone. So something to be mindful of.
So, given that we have run out of time totally, we will just say thank you all so much for joining us this morning. We will share the recording and the slides. You're very welcome to forward those on to anyone who couldn't be with us. We will also be in touch with everyone who's asked about the OH recommendations. So again, any questions that we haven't had time to cover, we'll share our contact details, get in touch with Tom or I directly. We'll be really happy to help.
Yeah, thanks, George. Please reach out. Super. I know we've run over a bit, but drop us an ad on LinkedIn if you're not already connected with us, and drop us an email if you did have any questions that we haven't answered and we haven't covered.
Super. Thank you all so much.